Hi and Assalamualaikum. Before I start with my case review, I would like to introduce myself first. I am Siti Narizafira binti Muhammad Raihan with the metric number 1252039. Okay, so in this case, I will present the enforcement of Islamic law in civil court, which is in the case of Brandon Yeoh Liang and Ketua Pengarah Jabatan Pendaftaran Negara.
Okay, so who is the plaintiff and defendant in this case? The plaintiff is Brandon Yeoh Liang, while the defendant is Ketua Pengarah Jabatan Pendaftaran Negara.
In this case, I highlighted three objectives, which is the first one, to determine the religion of plaintiff and the religion of the mother first, as she also has a confusing religious genealogy. Secondly, to analyze which court has the jurisdiction to decide in this religion matter. Third one is to know whether there is an enforcement of Islamic law in this court. As for the overview, the plaintiff in this case filed an originating summons dated in April 2025 to the High Court to grant a declaration that the plaintiff is and has always been a non-Muslim, and also in the nature of mandamus order the defendant to update the plaintiff's religious status to reflect the declaration given. Moreover, in early 2024, the plaintiff applied to the defendant to register his civil marriage, but the application was rejected by the defendant, where the plaintiff was advised to obtain a court order regarding his religious status for further action. Plaintiff in his affidavit stated that Yeoh Kiat Siu, as his father, is a Chinese descent, and Amoli binti Awang, as his mother, is a Malay descent, but there are no details about their religion. He only knows that his parent is in a relationship but never married to each other and eventually separated in 1995. Since then, he was raised alone by his father and has been practicing Buddhism while maintaining Chinese custom and tradition. When he reached the age of 12, he was given a non-Muslim identity card by the defendant, and not only that, throughout his primary and secondary education, his subject and co-curriculum activities did not involve religious education or element of Islam, and he had constantly attend moral education classes. He also believed that his constitutional right under Article 11 of Federal Constitution to profess and practice the religion of his own choice. Therefore, he solemnly declared that his religion is and has always been Buddhist since the date of his birth. Therefore, he is fully entitled to the solemnization and registration of civil marriage in accordance with the law in Malaysia. Defendant, in answering the plaintiff's affidavit, stated that the Special Consideration Committee panel dismissed the plaintiff's application to register the civil marriage as a temper due to the issue concerning religious status. There are three reasons, which is the first one, the plaintiff's mother was a Muslim at the time of the plaintiff's birth. Second, the GPN record that the plaintiff is a Buddhist, with the mother recorded as a Muslim and the father as a Buddhist. The third one is the plaintiff's mother was baptized as a Christian, but there was no Sharia court order renouncing Islam. There are only a statutory declaration. Therefore, the defendant stated that it is wrong to recognize the plaintiff's biological mother as a non-Muslim or a person who had left the religion of Islam. Thus, the power to determine this issue lies in the jurisdiction of Sharia court. The sworn statement made by the mother said that she does not practice Islam is insufficient. Regarding this issue, the defendant stated three reasons. The first one, the plaintiff's birth certificate and identity card did not state his religion, and his biological mother has been a Muslim since birth. Secondly, any dispute regarding the religious status of plaintiff's mother must be decided in Sharia court. Third one, as the plaintiff is illegitimate, issue relating to the lineage falls under the jurisdiction of Sharia court. The application for marriage registration by the plaintiff under Law Reform Act 1976 at 164 not applicable to the plaintiff, who fall within the definition of Muslim according to the Administration of Religious State of Selangor Enactment 2003. Therefore, if the defendant approves the plaintiff application for marriage registration under Act 164, such approval will imply that the defendant and the National Registration Department have recognized the plaintiff's religious status as a non-Muslim, where they do not have the jurisdiction to make such a determination. As for the legal analysis, the first one is Section 2B of Administration of Islamic Religion, State of Selangor, Enactment 2003. In this section, it was stated that a Muslim is a person, one or both of whose parents at the time of the person's birth were Muslim. Under the same enactment, which is under Section 53, allows civil court to say such expert opinion when Islamic law need to be interpreted. Lastly, under Article 1211A of Federal Constitution, stated that the civil court have no jurisdiction over a matter which fall within the jurisdiction of Sharia court. And it means that when an issue is clearly under the Islamic law and within the power given to the Sharia court, the civil court cannot interfere or decide on that matter. In this case, it was discussed. The court role is to properly assess the evidence before making a decision, which is JPN record confirmed that the religion of the plaintiff's mother was Muslim at the time of his birth, and the plaintiff was born out of a wedlock, making him illegitimate. Thus, the court agrees that the issue relating to the plaintiff's lineage fall under the jurisdiction of Sharia court. Moreover, when the Special Consideration Committee panel of JPN had rejected the plaintiff's application to register his civil marriage at a temple, the plaintiff did not file an appeal or seek judicial review against JPN decision, but instead filed his originating summons to overturn it. The defendant argued that the court jurisdiction depends on the plaintiff's religious status, which has not yet been legally determined. The plaintiff's religious status cannot be decided without first determining the religious status of his mother at the time of his birth. There is no Sharia court order showing that the plaintiff's mother left Islam, indicating that she remained Muslim in law. Until the Sharia court decides mother religious status, the plaintiff's religious status remained unresolved. Relying on the case of Rosliza binti Ibrahim, the defendant argued that even if the plaintiff are practicing Buddhism, that does not automatically make him as a Buddhist in law. Legal status are depend on a statutory rule and the fact of the birth. The court held that the expert evidence from Fatwa Committee is necessary to determine the key question, which is, was the plaintiff is a Muslim at birth or not? Therefore, it means that the court believes that the expert Islamic opinion is required before deciding the plaintiff's religious status, and this is when the enforcement of Islamic law come into a surface to resolve the dispute matter relating religion of Islam. In determining whether the plaintiff was never a Muslim is a serious and complex matter affecting religious identity and must follow Islamic law provision. Relying on the case of Kamaria binti Ali, the court held that statutory declaration alone do not remove Sharia court jurisdiction. The plaintiff's religious status can only be finalized after the Sharia court decides mother religious status. Until then, JPN was correct in refusing to register the marriage under Law Reform Act, which does not apply to Muslims, and the court agreed that reference to the Mufti is appropriate for determining lineage and the religious status. Therefore, it was held in this case, the originating summons was dismissed with cost of 3,000 ringgit to the defendant. To answer this case review objective, it is under the Sharia court jurisdiction to decide a matter of a religion of plaintiff and his biological mother. Moreover, there is an enforcement of Islamic law in this court, where the court asks for an expert Islamic opinion to interpret some of the issue in this case. That's all.